Okay, so we've got that started. And how's everybody?
Fine.
Good, good.
Actually, I thought you were going to send a message saying you had laryngitis or something.
If it was only that simple.
All right.
Are y'all seeing the slides now?
Yes.
Yes.
Okay, well, we've got several people in the waiting room. I'll go ahead and let them in, and then we can maybe wait a few minutes
Sure.
for other people to trail in.
Mm-hmm.
Welcome, everybody. I see people coming into the room. Definitely glad that you're here. We are just at the top of the hour, so with your permission, maybe we can hang out a minute or two to let other people transition into the training today. So it's really good to see. I see some people that have been with us throughout the series, and I also see some new faces, new names, and that's also awesome. So welcome, welcome, and we'll hang out just for a little bit longer.
Jason, can we find out where people are from, if they're providers or connected?
Yeah, I think that's a great
entity?
idea. And for those of you that want to use the chat, maybe you can type in definitely where you're from. That's helpful. City and state. I am from Elgin, Texas. And then if you want to share anything else, that's great. Oh, good. We've got Fiona. All right, we've got New Hampshire. That's great. Welcome, Sarah. Oh, we got Sharon back from California. Good. House of Extra Measures, Houston, Texas. Yep, Tim. Yep, you're Tim's from Houston as well. Beverly is from Lavernia, Texas. That's near San Antonio, if that helps you.
That helps me.
And if folks aren't able to chat in the chat box, you're welcome to come off mute for a little bit and let us know where you're from. Yep, we've got several people from Austin. Good to see you, Natalie. And I think I saw Fiona in the room as well. So Kim, once again, I think we've got a good representation of people from all over the United States. Yeah, we've got some Boston. Very cool. And in Texas, we've got allergy season, so I apologize for my coughing.
Likewise here.
I've got to love spring. Well, Kim, I have 2 minutes after, so maybe we can go ahead and get kicked off, and that way we have plenty of room at the end for questions.
Sure.
Okay. So let's see. Oh, okay. I just got a message that some will need to leave early. That's fine. Oh, we've got Richard coming in. He's from the San Antonio area. Know that this is being recorded, and one of the reasons is because we can share this with everybody who registered. So, all right, let's kick it off. Welcome to some new folks, and welcome back to others to Advancing Fair Housing for Individuals with Disabilities. This is a 5-part series, and we are in session 4. Today is going to be about fair housing and reasonable accommodations, and that's it's a really big topic for today. Just as a reminder, so this is being hosted by Recovery People. And I also wanted to acknowledge how we're able to support this. This is funding that we were able to receive through Project Homes. Project Homes is part of UT Health Houston School of Public Health. And really, this is using what we call in Texas, the Texas Targeted Opiate Response, which is and that funding stream, which is a public health initiative operated by the Texas Health and Human Services Commission through federal funding from SAMHSA, the Substance Abuse and Mental Health Services Administration. Today, our speaker is Kim Savage with the law offices of Kim Savage, and we're really blessed to have you for this entire series, Kim. And I am Jason Howell. I am with Recovery People and also supporting us on tech support. Oh, here's some more people coming in. Let me make sure that we get them in as well. And we also have Lisa Carter helping us out with chat and tech support. We have a parking lot. And Lisa, could you drop that link to the parking lot in the chat for us? The parking lot is where if there is a particular topic that you want covered, maybe it doesn't fit within today's topic, but you're like, wow, I really wish Kim would answer this. That's a document where you can go and put that. You're also welcome to enter that into the chat. We're capturing all these different topics, and that's what next session is going to be about. It's our hot topic session, if you will. So here's your opportunity to pose a question that might not be about reasonable accommodations today. Let's see. We really like engagement. So definitely use the chat. We're watching the chat. If you want to come off of mute and ask your question, that is perfectly fine. Zoom gives us these really cool icons, thumbs up, hand raises. You're welcome to use those as well. As I mentioned a little earlier, we're recording this. And so our intent at the end of the series that we will make the recordings as well as a PDF copy of the slides available to people. I think there's also been some other resources that we pointed to along the way. All that will be bundled up and made available to you and to the public. And a big reminder, this presentation is for educational purposes only, and it does not constitute legal advice. The alteration of this training content is not permitted. So with that, I am going to exit this slide deck and get over to Kim's. And Kim, I will turn it over to you.
Okay. Welcome, everybody. I like this cross section of the country, Texas, California, New Hampshire, and Massachusetts. That's really great. This training does have some Texas-specific information, but I would say overall it is quite applicable to everybody who's present today. Of course, you're from various circuit courts, so case law changes, but I think in terms of the major concepts and the analysis we'll go through about reasonable accommodations, you'll find it helpful regardless of where you live and work. Just by way of quick background, I am a California lawyer, a very different state compared to much of the nation, but I have done work throughout the country. My focus has always been working on housing issues related to the preservation of affordable housing and the development of housing opportunities. And for the past decade and a half, I've really focused on using civil rights laws to develop and expand housing opportunities for individuals with disabilities. And even more specialized, I've really focused on housing programs for individuals with mental disabilities and those who are in recovery. This is the fourth session, as Jason said, and you will have an opportunity to review the first three sessions. as well as this one. And the first one was a general overview of fair housing laws. It's pretty meaty. And since the Federal Fair Housing Amendments Act and Texas fair housing laws are basically the same, I usually speak in terms of the federal statute. I can't comment about Massachusetts or New Hampshire, whether they have state statutes. You could certainly let me know that if you'd like. California has a very strong state fair housing statute, quite inclusive, and it casts the net further than the Federal Fair Housing Amendments Act. Let's see. I will say what I say every single time because some of you are here for the first time, which is my goal is to have you be able to spot a potential problem and know when it's time to go talk to somebody. And that somebody is typically a lawyer who works in this area. I don't expect people to walk away feeling like they want to go to law school or they have the knowledge of a lawyer who's practiced for decades, but I think it's sort of my red flag approach, which is, these facts don't seem quite right, or what I'm being told doesn't seem quite right, or I need to check it out further. So that's really the goal of these training sessions. Let's go to the first slide. This session on fair housing, reasonable accommodations is really focused on recovery and other housing providers for housing for people with individuals needing some kind of accommodation for their housing program to operate. This is not focused on individuals making requests of their housing provider for an accommodation. That said, the analysis in broad terms is really the same, and we'll get to that. And we could certainly at some point, if we wanted to in the last session, take as an example an individual seeking a fair housing reasonable accommodation request from their housing provider, and that might be extremely helpful to providers. But at the moment, we are really focused on land use and zoning and fair housing, and so we want to analyze how do you get local government to agree to provide you the accommodation you are seeking. It's a unique area. That's one of the reasons why I work in this area. There aren't that many people who do it, but as I always say, if you cannot get through the zoning process, get through the planning approvals you need, you're not going to get your program operating. So let's go to the next slide. So these are the objectives of this session: to understand the statutory-based framework of analysis for requesting fair housing reasonable accommodations, and likewise what the decision maker needs to be setting forth in their analysis. Learning how to develop your supporting evidence, facts for making a reasonable accommodation request, and then being able to evaluate the decision-making process and whether you think it was appropriate, or maybe you need to appeal it, or you need to head into court if there's not an administrative process that allows you to appeal it. We'll also get into the interactive process, which is relatively new, which basically states that the parties need to sit down if there's going to be a dispute and try to resolve it. It's kind of the mediation approach, which most lawyers favor these days. Next slide. So this is the basic requirement of reasonable accommodation. Local governments have an affirmative duty in the application of land use and zoning and other housing related regulations, rules, and procedures to be flexible or even waive a requirement if it is necessary for equal access to housing for people with disabilities. That is a very broad statement, and it's reflective of fair housing statutes, the federal fair housing amendments. It is an incredibly creative tool for seeking what you need to address what I call a barrier to housing. And I refer to it as the golden tool. So in addition to this reasonable accommodation provision being in fair housing laws, it's also in the Americans with Disabilities Act and under Title II, which applies to state and local governments and their programs and activities needing to provide equal access to local government. Reasonable accommodation is also available. Just to confuse you, under the Americans with Disabilities Act, the term reasonable modifications refers to actual reasonable accommodation. So I don't know, it's an unfortunate wording by Congress. So under fair housing laws, it's reasonable accommodation. And under the ADA, it's reasonable modifications. And to just make it more confusing, under fair housing laws, there is a term reasonable modifications, which you're all probably familiar with. That reasonable modifications refers to physical alterations of property so that someone with a mobility impairment has access to housing. We distinguish reasonable accommodation from modification by saying if you can pick it up and shake it, it's a modification. It's not, it's an accommodation. So accommodations, which is what we're focused on today, is rules, regulations, procedures. The second statement here is really important. The availability of reasonable accommodation does not cure a intentionally discriminatory ordinance provision. You might be dealing with local government and you are alleging that a particular provision in the land use and zoning code intentionally discriminates on its face, singles out housing for people with disabilities or a particular kind of subcategory within housing for people with disabilities. And the response is, oh, well, that's okay. We'll just provide a reasonable accommodation in this instance so that you have what you need. And by the way, that you don't complain in the future. But the fact is that intentionally discriminatory provision needs to be eliminated. So it's it's a particularly important point for lawyers, but for you to know that also. Next slide. Thank you. So this is the Fifth Circuit's statement in a really important case called Groom, and it's cited at the end in the endnotes. And there's probably similar cases in most circuits throughout the country. But it's worth reading, which is that the reasonable accommodation language specifically targeted the type of zoning regulations, single family residential, at issue here. So that first sentence is the court is and I'm going to get into the facts of this case. The court is addressing a very limited zoning restriction in the single family residential zone. And the court goes on to say, Congress found that these seemingly neutral rules and regulations, even those involving commercial, non-commercial zoning distinctions, nevertheless had a discriminatory effect on housing choices available for the disabled. So we spent time in the first session talking about discrimination theories. And we know that there are some things that are on their face in a zoning code single out in a discriminatory way certain types of housing for people with disabilities. That's not so obvious these days. Most jurisdictions understand that on the face of an ordinance, you can't be restricting a particular protected class. But there are neutral rules and regulations, which some have a discriminatory motive. They are specifically intended in a subtle way to restrict housing opportunities for people with disabilities. And sometimes there is no ill motive or intent at all, but the effect or the impact of a rule falls harder on members of a protected class. I'm focused on disability today, but as you know, there are other protected classes under the federal statute and the state statutes. But, and so it's not intent to ignore them, but this is just really focused specifically on disability. And reasonable accommodation is a tool that is only available to individuals with disabilities. It does not apply to any other protected classes. So I should step back and say, so why is that? Because sometimes you will hear, or if you may not have already, I've certainly heard it in people in the audience in training sessions for years have said, I don't understand why you're giving individuals with disabilities or increasing housing opportunities. Why are you making it easier for individuals with disabilities or the development of housing for individuals with disabilities? There are several responses to that, at least, and I can think of two off the top of my head. One is that historically, individuals with disabilities have been discriminated against. And it still seems okay to do that. And so we are addressing historic discrimination. And the second is we have reasonable accommodation tools to address the uniqueness of anyone with a disability. So each person's disability is unique to them, and it plays out differently in their life and their work and in their family. And so we can't have a single approach. We need to provide access to housing in a way that addresses the specific barriers created by the individual's unique disabilities. So we're not really giving anybody a leg up. We're trying to level the playing field by addressing barriers or impediments to housing. Let me finish with the last portion of this slide, which is Congress recognizing that basically the people with disabilities need a variety of housing opportunities, living independently, not necessarily living in a structured environment. So quickly, let me tell you about this case. It was not recovery housing. It was a very small Alzheimer's group home. This is a case from 2000 out of Louisiana, Fifth Circuit. The definition of family will sound quite familiar to you. People related by blood marriage, adoption, or court order, but no more than 4 unrelated individuals. The people operating this Alzheimer's group home wanted 5 individuals. And the local government was actually supporting this and planned to grant the reasonable accommodation requested of this small group home until a neighborhood organization sent a letter to the city and said that they opposed it. The city did nothing for 95 days. And although they didn't have a written reasonable accommodation procedure, they had indicated that they try to give responses and make a determination on a request within 45 days. The Alzheimer's group home folks just decided they were tired of waiting. They filed a lawsuit. And one would think, this is premature. They're not allowed to do that. They have to wait till they get a decision, like an adverse decision from the jurisdiction, before they can go into court. And this went up on appeal. That's why I was with the Fifth Circuit. And the Fifth Circuit said no. Basically, that housing discrimination is a unique and immediate injury. And so they could come into court. That's a really important statement for all of us, that the courts recognize how important it is for someone to have their housing, that when they're subject to discrimination, they can move more quickly. There was also some interesting, I'm going to just read you just a short little paragraph from this case, because you may run into this or you may have already. And the court said the deposition testimony revealed that there was no planned application on no planned action on the application. That means the reasonable accommodation application. And the district court found that the attorney in charge of the review process could not say what the current status of the application was, what, if anything, remained to be done to complete the process, or when it might be done, and could not say who the ultimate decision maker would be. The district court concluded that the parish delayed acting on the application in the hope that the matter would become moot if the proposed purchase of a home fell through. Therefore, to deny plaintiff's claim as premature would effectively frustrate the clear mandate of the Fair Housing Act. So the reason I read this was so I wanted to spotlight the behavior of local government, which in this instance was a parish. They just sat there. They did nothing. And that's because they received opposition from a neighborhood organization. So they just sat there. And in this instance, the facts involved the purchase of a group home, or purchase of an actual single family dwelling. And I should have told you this before, but the Alzheimer group was seeking approval first before they bought the home. That's not necessarily the approach I would take, but that's what they did in this instance. They were being extremely cautious. We'll check with local government and see if it's okay to have one more person in this home in a low density single family dwelling. And so if it didn't involve the purchase of a home, what I've seen before, and you may have heard or experienced, is that the local government, when they get some pushback, they might just do nothing in hope that the matter will just go away or the person seeking the accommodation will give up. And this is telling you basically, don't give up. You need to move forward and push for a decision, or you can take other steps. So that's the Groom case. It's cited at the end if you want to read it. It's a pretty readable case, interesting facts. Next slide, please. We have no questions so far, right? Nothing?
No
Yeah.
questions.
Okay, thank you.
Are-
Okay. Yep. But
Katie,
Jason,
was that you had a question or that you did not have a question?
No, I'm sorry, I have headset on. No, I don't have any questions.
okay. All right. Okay, so this is a comparison of requesting a fair housing reasonable accommodation versus going through a traditional planning process. And in Texas, I think it's typically called a rezoning process. But you may also have conditional use permits. You may have a variance. The term special use permit is used. There may be others, but I think what we're saying generally is we're comparing requesting something based on civil rights laws versus seeking some kind of extra approval and entitlement based on planning regulations and codes. They're very different. Reasonable accommodation looks at the needs of the individuals with disabilities. And by that, we also mean the housing provider of housing for people with disabilities. It typically, if a reasonable accommodation is dealt with according to statute, there shouldn't be a public notice and hearing process. It's not based on aesthetics, but it does include a burden analysis, which is important. In other words, just because one requests a reasonable accommodation doesn't mean that there is an obligation on local government to provide it. We're going to go through the analysis. So in an entitlement process or rezoning, those typically look at a general welfare standard. Will the use or whatever is being asked for be detrimental to the health and welfare of the surrounding community? That's typically what we see, and I believe that's very close to the Texas state language that we talked about in the previous session, session 3. The typical entitlement process doesn't look at the needs to access housing, that there might be some impediments or barriers in the current zoning code that prevents individuals with disabilities from having access to housing. And of course, we know there's a public notice and hearing process, And as the California Attorney General, Bill Lockyer, said years ago, it's the wrong standard for civil rights matters. So I'm going to digress just to tell you a little bit about California. We have, after a bit of work,
Beverly, did you have a question? Go ahead.
her mic went on, so I'm taking that as a no. She went on mute.
Yes, Beverly, in case you have a question, your audio was kind of garbly. Maybe you can enter it in the chat, or I see you're off mute again. Do you
Yeah,
have a
go
question?
ahead.
I didn't have a question. Sorry, just hit it by mistake.
Oh, okay. Oh, you didn't. Okay. All right. So we can talk about this later today, or we can talk about it in the last session, but we were able to get in a very long bill which addresses housing in, I think, 2001, a requirement that every city and county in the state of California have a reasonable accommodation procedure to address land use and zoning matters. So that's a fabulous thing for us in California. It was preceded by a letter that I was able to get from the state attorney general at the time, which is what led to this slide, actually. And this really came about by a client asking me to do this. And the client said, okay, now we have a new attorney general. Would you please ask him to do something about all of our problems citing housing for individuals with disabilities? That led to a letter which came out from the California Attorney General, who analyzed these different approaches to helping to further housing opportunities for individuals with disabilities. And if anybody would like to see that letter, I can certainly share it. It got the ball rolling. And so that led to the legislation, which is extremely helpful. That was, a kind of a side story I wanted to tell you, but I think it's extremely important. It would be wonderful for other states to be able to include this in a bill at some point. Next slide, please. Oh, yeah.
Kim, I have a question. So it's been my experience that some local government, even local government from very large cities, seem unfamiliar with reasonable accommodation. Are they statutorily required to have a reasonable accommodation process, and or if they're receiving certain federal dollars, are they required to have a reasonable accommodation process? I'm just kind of wondering,
Right.
as we approach, and they always seem that they want to drive us through kind of rezoning, and I don't know if that is just strategy on their part, or that's kind of their normal way of doing things, and get that there's reasonable accommodation.
Right. Okay. So our state requirement is just that. It doesn't have a hook. What we do have is a housing element process, which is we have a 5-year planning document that every city and county needs to do, and we have been quite successful in working with the department that reviews those. And so as part of their checklist, they make sure that the jurisdiction has a reasonable accommodation procedure. However, that does not ensure by any means that the people who are running the planning department or community development department even understand what this is or even know about it. So I would say that the trickle down has not been great. It's getting better, but it would be nice to strengthen that aspect of it. Of course, every state has the analysis of impediments. And so I think, the checklist approach is probably the way to go. We've tried to make sure that the analysis of impediments brings this forward. It's such a powerful tool, which is why we're spending a whole session on it and here today, but also why we put in a lot of effort in the state. It's extremely helpful in addressing impediments, whether intentional or not, that arise when one is dealing with local government. So I think I'm a little bit stuck on this, but I see every jurisdiction having a procedure as actually being helpful to them. And I think that there's a way to promote this at the state legislature in many states. Probably not all the way throughout the country, but I think in many states, it is extremely helpful to have this requirement in place and have a standardized approach to deal with requests, because they're increasing. And we know that disability is the #1 area in fair housing. So next slide, please. This is the basic analysis. And we'll go through it. And then we might, for fun, take an example when we go through the actual analysis that might make it a little more meaningful. But here's the analysis. The first question is whether the housing that is the subject of the request for reasonable accommodation is for individuals with disabilities protected under fair housing laws. And we know people currently in recovery for substance use or abuse are protected under fair housing laws, as well as the ADA, as well as Section 504. They are individuals with disabilities. Whether the requested accommodation is necessary to make housing opportunities available to individuals with disabilities. This is the nexus. This is the tough one. This is the toughest of the analysis, and we'll get into it. And so if the answer to the first two questions is yes, then you have a burden analysis, whether you look to whether, or this is local government or whoever the request is made to, can assert that what is being requested is an undue financial or administrative burden. And then would it require a fundamental alteration in the nature of, in this instance, land use and zoning programs? I realize now that I didn't respond to Jason's comment about local government putting a requester through the rezoning process as opposed to, or before, maybe looking at reasonable accommodation. So the cases nationwide, the cases are not consistent. I haven't looked recently at the Texas case law. I certainly could, but some states will look just at the reasonable accommodation request. Certainly that's the way it is in California because of the mandate that there be an actual process and in writing. Some states will ignore it and just say we go through the rezoning process. And then there's some cases say that it's okay to require that the person requesting the accommodation go through the rezoning or some other entitlement process, which is the standard procedure. And then if they lose, they can go through the reasonable accommodation process. And then I've seen the two kind of fuse together going on at the same time. So the second to the last is bad. The very last one is sort of interesting. I mean, I've seen just with some of my cases that a county council went through the analysis of both, which I thought was very odd. But yeah, it's not I don't know what the answer is today for Texas. It's something I could look into. But the last time I checked, there was not consistency nationwide. So hopefully that helps. It doesn't give you an answer, but it lets you know that it's not completely clear throughout the nation, not consistent. Next slide, please. Okay, so these are some basic principles that I live by and I think will be helpful to you. Certainly, you can make a request in any way you would like, but the best is to have it in writing. Of course, you're memorializing your request. A request can be made at any time. I will tell you that when in the landlord-tenant situation, the requests can be made up to and in the middle of an eviction proceeding, which is pretty remarkable. But so when we're talking about land use and zoning, a request could be made at any time. I, of course, suggest to my clients that they make their request before they're actually violating the law. It makes it easier to get your request granted. There's no limit on the number of requests that a housing provider can make. No fee should be charged, although some jurisdictions charge for certain type of requests, but not others. For example, an individual making a request for basically, let's say, going above the fence height restriction because a family member needs greater privacy because of mental disabilities, that some jurisdictions would say no charge, but if it's a housing provider seeking to increase occupancy, well, they feel they can impose a charge. My view is there shouldn't be any fee charge because there shouldn't be any burden or barrier for exercising your rights under fair housing laws. No notice in public hearing process, which of course is required under the typical planning process. And that's one of the primary reasons I tell my clients, let's try the fair housing reasonable accommodation approach to avoid the public notice and hearing process and just have somebody behind the desk or a couple of people making a determination, as opposed to having a public hearing, a notice public hearing process, confidential information could be exposed, and no one likes to listen to a lot of opposition. Unreasonable delay in decision-making may be deemed a denial. There are cases on that point. And important to remember that these are case-by-case determinations. There are no categorical approved requests or those that are automatically denied. Each request is viewed on its own. Next slide, please. Okay. Tim, are you here? You're here, right?
Yes, I'm here, but I'm in the
Okay.
call.
I have a question.
Yes,
I think you were the person who brought up the idea of having a program in a commercial zone.
yes, it's currently a commercial zone.
Okay, all right. So I just got a call about that also from someone in California. So should we take that as our example through the analysis? Is that
Sure.
okay?
Sure.
Okay. Somebody have something else they think would be a better one? It came up twice in a week. I thought it'd be a good one to use. Okay. All right. So the scenario is just that a recovery housing provider wants to provide housing in a commercial zone. We're not going to worry. Oh, well, Tim, tell me what the building's like.
Historically, it has been a hotel.
Okay, perfect. Okay, that's
Yeah,
that's good.
so go ahead.
Yeah, that's good. I was afraid you were going to tell me it was a historic building. We don't want to
No,
get it.
no.
Yeah, okay, good. Okay, it was a hotel. Okay, super. All right. So the goal is turn this hotel into a recovery residence. So the
Yes.
first question is it housing? And Tim, you can jump in if I'm starting to go, you know, off too far off from what you're thinking about. And you don't
Okay.
need to disclose much. I just, you know, thought I think it's a good example. Because there are a lot of hotels that are in disarray, deteriorated, and they might be, they might provide an affordable piece of property to rehab and use for recovery housing. All right, so the first question is it housing for individuals with disabilities? You go to the city, what kind of proof do you have? Housing provider can verify that it's housing specifically for individuals with disabilities so that you are entitled to the protections of fair housing laws and can make a reasonable accommodation request. You can provide information if it's a nonprofit, your mission statements, your website, corporate documents. You can provide basic information about eligibility, if you have NAR certification, even testimony of employees and residents is a good way to verify that you are actually providing housing for people with disabilities. And of course, the funding source can also be used.
Okay.
Important to understand that individualized proof of impairments in recovery home setting is not required. In other words, local government doesn't get to say, we want to see proof that every single resident is an individual that meets the definition of disability. That's not required. On the other hand, it's not a per se disability. There's a case from a few years ago which found that even though individuals were in recovery for an alcohol addiction, they were not truly disabled. There's nothing that indicated that they couldn't go to work or engage in outside activities or that they couldn't live alone. So even though you don't need individualized proof, you need to understand that you're going to need some level of proof. And there's a case that we talked about in the second section when we talked about what is disability, what does that mean? There's a case with some really good language about individuals in recovery needing to live in a shared living arrangement because they can't live independently or alone. They need a level of support to avoid using again. And that support is referring to psychological, emotional support for staying in the recovery process. And then some individuals are unable to work at times. So we can establish pretty easily that what's going to be provided at this hotel is housing for individuals with disabilities. Next slide, please. And that gets,
Hey, Kim,
yeah,
hey, real quick, one of the tools that I looked at is the N-STAR study that Jason had out. And in this particular region, it showed a very high need threshold and vulnerability in this particular county location.
that's the next
So
slide.
Oh, okay.
That's perfect. Thank you. Tim is not a plant, but he could have been. Okay. That's actually great. That's really great. Is the accommodation necessary? So Tim did his homework. So you have to, okay, so here's the, what are we asking for waiver of or flexibility in? And that is that we want a residential use, because that's what recovery residences are. We want a residential use in a commercial zone. We don't want to say, oh, I'm a commercial use, so I can slide right in. You do not have the protections of fair housing laws if you have a commercial use. It has to be a residential dwelling. So I'm going to operate a recovery residence, which is a residential dwelling, and I would like you to be flexible in your rule that says we can't have a residential use in a commercial zone. And why is that? Well, Tim just started to answer it until I interrupted him. There's an incredible need for this type of housing in this area. Keep in mind that one of the goals in all types of community programs, recovery programs, mental health, is to have people integrated in the community. They're close to jobs, they're close to family, they're close to friends, they're close to friends. All of these things help in the process. As we said in a previous setting, that it's the community of choice. It's not a neighbor's choice to say, go move your program to a high density zone or go find another home. I'm sure there's others like it in a different neighborhood. You know, that this is the NIMBY sentiment that you may run into. Okay, and I've said before, highly fact specific inquiry on a case-by-case basis. Okay, let's next slide, please. So these next two slides are approaches that I've used in increasing occupancy for my clients. And I've probably done a dozen of these in California. Tim is already on to some of them. But one is the therapeutic benefit. You all know there are studies out there that talk about what is a good number or an ideal range of residents in a recovery home. There's lots of studies on that. Financial viability is recognized as a need to increase the number of residents. Keep in mind, it may require disclosure of specific and detailed financial operating accounting. So you would have to be prepared to show that if you wanted to argue that I need more residents. Well, this is an increasing occupancy situation. This is not Tim's. We'll get back to Tim's in a minute. But also the courts disfavor just asserting that you're trying to make more money. So that's something to keep in mind when if you are trying to increase occupancy and you want to assert that you need a greater income. Needing to break even is probably the best approach. Now, someone could use this financial viability argument just by going into a commercial zone and taking over a property that may be low priced because it's sort of, it's falling into disarray or not. I'm not saying Tim's considering a property like that, but I mean, this financial viability could be an argument would make. This is the zone in which I can get something that I can afford to operate a program. Next slide.
Yeah, real quick, when you were talking about occupancy, so I have seen those studies. There's a study of Oxford House that looked at outcomes were better in a home that had 8 or more people versus those that had 7 or less. But I'm thinking about like the top end. Is there a point where you have a number of beds or individuals in a dwelling that starts going past something that looks like a single family unit, and have the courts given any indication of what that threshold might be?
I have a touchy-feely approach to it based on experience. I think once you say 12, well, first of all, let's step back. I should say, we need to look at the dwelling size. People are really, and including local government, are really stuck on a 2 per bedroom occupancy limit. And so sometimes you have to educate people. That is typical of state licensed facilities. They they say they want, the standard is 2 per bedroom, but they even have waiver and grant exceptions. So I think it's important to look at the number of bedrooms in a dwelling. This is a hotel, so it's going to be, number of units, and the size of them. But I have found from my experience that when you hit 12, people start thinking, that doesn't sound like a family to me. That seems kind of large. And then what follows after that is, well, what about cars? That seems the big one. Cars and where are they going to park? I off the top of my head, I don't know of any cases that have done an outer limit. And then I think that's probably because of the first factors I mentioned. You're really looking at number of bedrooms, number of units, square footage. But I've had clients who have wanted to, double, go from like 6 to 12. And I think that's too big of a jump. But some jurisdictions have such limited definitions of family. Okay, so let's say it's, no more than 4 unrelated, like that Louisiana case. Doubling is not unreasonable if you have a large home. It's all how you kind of just work with local government and how you describe it to them. But it does take educating. There's no doubt about that. Next slide. Okay. So another argument is just the basic fair housing rationale, which is that your restriction on commercial uses only in commercial zones is denying housing opportunities that are there, ready to be used. And you're also not affirmatively furthering fair housing by being flexible. And the next is what Tim was getting onto, which is really, really what I rely on, which is proving up an unmet need for a specific housing use. I do a lot of research. I look at census data. I look at SAMHSA data, which gets very, very detailed. And I can almost always present an argument that there is a very large unmet need in just about every jurisdiction throughout the country. Sadly, Texas has a lot going for it in terms of unmet need. It ranks way down the list on access to recovery housing and mental health programs. So it's a deep dive. Tim, I think you're headed in the right direction, that's for sure. The uniqueness of the housing program also, I think, could be helpful. For example, if someone is operating a women and children's residence, that's very important and very, very rare. And I think something that has, frankly, an emotional impact on people.
Yeah. The focus here that we tried to approach, of course, I come from a single family residence and have 4 of those and experience with that, 5 of those, and different sizes. And many of the comments and experience that I have from that, even the sharing of bathrooms, no more than 3 per person, and bedrooms, and they're good sized bedrooms, no more than 2. So just out of my experience and the clients that I'm dealing with, that seems to work well. Yes, but in this particular commercial, all of that wherewithal, if you will, is coming together, because now the bathroom situation is resolved. The different floors, you can make male, female, and then 3rd floor, single parent families.
Mhm.
the accommodations as far as an in-house gym, swimming pool, meeting rooms, all of that,
Mhm.
you know, it seems to be falling in place.
That's
Uh,
great. That's great. The level of detail in presenting to local government just cannot be overstressed. A lot of what you're doing is making the person on the other side of the desk feel comfortable with what you're proposing and being able to say that to the next person up and to be able to write a staff report if necessary, which justifies flexibility or waiver of certain requirements. I think I saw something in the chat. It flashed up and then,
Yeah, we've had people that had to step into other meetings.
okay, got it.
And Lisa, just a reminder, Lisa Carter has put the link in for the parking lot if you want to add any hot topics for next session. And she also included a registration link for next session.
Thank you, Lisa. Okay, next slide. So this is establishing reasonableness for a fair housing accommodation in the Fifth Circuit. The person making the request has a burden of establishing reasonableness by a preponderance of evidence. It includes establishing that there's no burden to local government, which we'll get to. And the burden does not shift to local government to establish unreasonableness. So it's a little bit unique in the Fifth Circuit. And the Fifth Circuit has also said reasonableness involves a balancing of the parties' needs and interests. Are there alternatives that would accomplish the benefits more efficiently? So this gives you a framework of how a court would look at this. And so at the lowest level, when you are making a request to a jurisdiction, you will want to make sure that what your request is reasonable and addresses any concerns that you think local government might raise. Next slide. Thank you. Okay, this is the burden analysis. So is what is being requested, which is to operate a recovery residence in a commercial zone, going to burden local government? Generally, it costs nothing to waive a land use or zoning regulation in granting an accommodation. And there's actually a reduction in the administrative burden if there's no public notice and hearing process required. You aren't asking local government by providing a recovery residence in a commercial zone, you aren't asking local government to pick up trash more than once a week or to any other government service. And so that relates to something we talked about last time, which is if you've been a provider like Tim before, you have a track record and you can say, my recovery homes operate really well. I think we called out the police maybe once a year in each homes, or we never have. We are not burdening services of the local government. A pretty important thing, something that gets raised by neighbors. And then fundamental alteration of the zoning code. So the case law is quite good on this. Basically says that granting an accommodation for a single dwelling doesn't result in a fundamental alteration. So a fundamental alteration of the zoning code means there would be total upheaval of the zoning code. And it would essentially be wiped out or so changed that it would undermine the operations of local government. I've never seen a case that has found a fundamental alteration of the zoning code. Next slide, please. Okay, here's some examples. And these are just examples of things that I have worked on, but I can tell you it's endless. It's as long as you can get through analysis, prove that it's reasonable and what you're requesting is not burdensome. I mean, the sky is the limit, as creative as you need to be to meet your program's needs. Of course, the first one is the one we talk about the most, which is increasing occupancy beyond what a definition of family states. Reducing or waiving distance requirements between residences. I'm not sure what Texas has, but California has a over-concentration rule, which says that state licensed community care facilities of 7 or more need to be a certain distance apart from each other. Every year, somebody in the legislature proposes having distance requirements for state licensed alcohol and drug treatment programs, but every year it fails. But if you are in a jurisdiction where there are distance requirements, which are questionable under fair housing laws, you could request waiving a distance requirement, waiving fence height restrictions, using other parts of the dwelling for uses other than what they may have not been originally intended for, like using a garage for program activities, or single family dwellings where there's a small cottage in the back, turning that into meeting rooms or private rooms to meet with the social worker. Waiving parking restrictions, that's a tough one, but if you've got your own rules that say you don't allow people to have cars at the recovery residence, then that's something that's very reasonable. And then the last one, which is permitting a residential use in a commercial zone. There are lots and lots of possibilities out there. So you're not limited. You're not limited by what the factual setting might be, but of course you are working within a legal framework of analysis. I've just thought of another one, which was not a client who bought a duplex and he wanted two state licensed facilities right next to each other. And of course, there was a distance requirement for something that he had. I think it must have been a community care facility. And it was in a duplex. So we were successful in waiving the distance requirement on that. Questions or comments by anybody right now before we go on? Okay, let's go to the next slide. Okay, so actually we didn't take the example, I'm sorry, through the burden analysis. So you don't need to go back on the slides, but okay, so for using the hotel as a recovery residence in a commercial zone, well, we can work backwards. It is not a fundamental alteration of the zoning code. You're only asking of one building, and I don't know how large it is. But the other factors that might go into this is the location of the hotel. And I can't remember if you said, Tim, that it was on a corner or only what the location was.
Yeah, it's on a well-established thoroughfare, has parking, egress, and et cetera already established.
Okay. All right. So, that use can slide right into that commercial zone and certainly not undermining the operations. And if it's on a somewhat busy street in a commercial zone, I mean, I would argue that it's even more stealth-like in being in that zone. And then working backwards, financial or administrative burden. I mentioned it earlier. I don't think we have that in asking for approval of operating a recovery residence in a commercial zone. Can anybody think of a financial or administrative burden?
The thing that I would look at, just like in HOA, is and what you had mentioned in an earlier segment is okay. No additional on constables, policing.
Mhm,
We have records.
mhm.
We have statistics. We have no additional inspections required. From my notes from today, it's actually a reduction of burden on the local government. For those reasons, there is, and go ahead and answer proactively in case the person you're talking to, as he runs it up the flagpole, gets asked the question. There's no fundamental alteration that we're asking for.
Right, right.
And go ahead and answer that in parking exceptions. They already have that for previously, so that should be no. And go ahead and ask those, click those boxes
Mhm,
preemptively is what our plan would be. I would think going forward there.
mhm. Are you completing a form or did you just make this request in some other way? Was there a actual procedure that you're undertaking?
Well, the current owner has a longstanding relationship with the local authorities there and has relationships inside.
Mhm.
And against my advice, went ahead and said hello to his friend and said, "Going to be any problems here?"
Oh, okay.
And so, but no, we're just formally trying to go forward uh, and put the plan together for the area.
Mhm,
And I
okay.
think it'd be a great addition.
Mhm. Did something pop into the chat?
Yes, we've got a separate example.
Okay,
that
perfect.
we can get to in a little bit. One of the things that, but before that, something that you said, a financial burden, reminded me that last session when Tim was describing this opportunity, that the landlord was going to charge him triple net when it comes to utilities, and we see that many times, even in residential settings. If a landlord has a home, a recovery home, wants to move in, they start charging triple net, which is what utilities, insurance, and I forgot what the third is, but it's typically what you would see in commercial leasing. So that popped in my head, and I was wondering if you had any thoughts around that.
Well, I think you need to try to persuade them that it's not a commercial use, that it is a residential use. I don't have any case law on that, but on the triple net, but there is case law that indicates that recovery residences are residential uses. I think there are people out there that just believe that recovery residence providers are just making a bunch of money. and and they believe it's a commercial use. But I mean, if it were other than a recovery residence use, if it were a bunch of college students or post-college students renting a single family dwelling, would that be triple net be imposed on them? We're talking about a shared living arrangement. We're not. Yeah, I mean, I can't. I'm sorry to hear that. I'm not sure that I've heard that's going on in California, but yeah, I mean, there's case law that establishes that these are residential uses. But I also realize that it's hard to get into these leases. So you feel like you're at the mercy of the property owner.
Right, right. So turning to the chat, so Patrick, and I believe this is from Massachusetts,
Okay,
Might be too specific and not sure if it's covered under reasonable accommodation. But MA, which I think is Massachusetts,
yeah,
has a law that a lodging slash boarding house must be protected by a fire sprinkler system. And he quotes a section 24H. They state it must be done if there are 6 or more unrelated people. I know shared housing should be different, but our NAR affiliate has been informing us that there are certain towns enforcing this as a way to keep out shared housing. Do you have any suggestions?
well, first let me say that I've heard of this approach by local government in numerous states, in numerous states. The question that to me, the basic problem is that recovery housing is being pushed into a boarding house classification. So it's a misclassification of use. And I don't know if the reliance is on the zoning code or the fire codes, which are incredibly difficult to read and understand. But it sounds like they've got a definition that is just sweeping any kind of household of unrelated individuals that exceeds 6, which is very problematic. There is very good case law which addresses fire and life safety requirements. And it states that the regulations, the requirements must meet the actual needs of the individuals living in that housing. And that's what this slide is about. I have worked with fire chiefs and in trying to think where that was, Washington, D.C. or Virginia. I would have to look back at my notes, but I worked on something where the state fire marshal actually agreed to waive a sprinkler requirement for recovery residences as a fair housing reasonable accommodation. But then also included a warning that if there were any fires or any problems, he was going to rethink all of this. I could find that again for you, but it is a real problem, which is why I devoted an entire slide to this, because I mean, my clients have educated me on the cost of these. The other thing is there are some very bright lines when you talk about ambulatory versus those who are non-ambulatory. That is significant. And so for a fire code to lump all these populations together is a real problem. And I mean, it is potentially discriminatory impact. It falls more heavily on housing for individuals with disabilities who live in basically independent shared living arrangements. So I mean, we could talk about this another time. If you want to, you can reach out to me. I mean, I've worked on this issue in a couple of states and really, I say this truly, I was shocked that we had success. I was completely shocked just through discussions back and forth. So you're welcome to contact me. We can talk about it outside of the Zoom call.
I believe there's case law out of Louisiana that it was around the parish requiring an Oxford House to install a sprinkler system, and the judge ruled in favor of Oxford House. So
Right,
it might be something that we carry into
Mhm.
next session and do a
Right.
hot topic over
It-
case review.
it is definitely an Oxford House case, and it's got some great language in it. But I think there's one or two more cases also. I mean, it's been a very a big focus because of the cost and just the unnecessary uh heightened requirements. Next slide. Thanks for bringing that up, by the way. It is going on all over the place. Okay. All right, so this is the interactive process, which I mentioned before. This is the idea that the parties, the requester and the decision maker, should sit down at the table and try to reach a resolution, an alternative accommodation that still meets the needs of the requester, before making an adverse decision. So this came out of HUD and DOJ, created this interactive process idea. And it took a number of years before the phrase was actually used in cases. And so it is now mentioned in certain cases that the party should engage in essentially a kind of negotiation, mediation, to see if they can come up with something that is an acceptable alternative accommodation. And the housing provider is not required to accept it if he or she doesn't feel it meets their needs. But if you are in a situation where it seems there's going to be a denial, you should bring that up, or you should bring it up in advance in your request by saying, if you intend to deny this request, before doing so, we should sit down at the table and engage in this process. So it is recognized now, but certainly when HUD and DOJ first came out with this phrase, it was nobody paid attention to it really, except the housing advocates. Next slide. Thank you. Okay. Now let's look a little bit at the decision-making process. So like all land use and planning decision-making, it needs to be based on the facts and the law, and not on generalized kind of comments, statements, prejudices about individuals with disabilities. Discriminatory intent against local government can be found where zoning decisions are based on public comments and not the facts. So if you've ever viewed a transcript of a public hearing, those transcripts will often give a little summary of what people said, those in support of and those opposing whatever is the subject of the public hearing. And that's okay, provided it's accurate. But it's not okay for the decision makers to adopt negative, adverse comments as part of that decision. They are supposed to be making their decision based on facts and law. Procedural deviations in decision-making involving housing for individuals with disabilities may evidence discriminatory intent. And this requires you to know, what's the administrative process, the administrative review process and decision-making. And make sure that in your request that process is being followed. Now, I understand with reasonable accommodations, there may be absolutely no process. And so I think what you need to press for is that there is a prompt review and that the decision articulates the rationale for why something was approved or not approved. So let's go to the next slide. Right, okay. Here's what a written decision should look like. It should be timely, which is 35 to 45 days, 30 to 45 days. It should state specifically why the accommodation is granted or denied, not just conclusory statements. A conclusory statement would be something like, we don't think it's necessary, or we just don't allow residential uses in commercial zones. That's not good enough. That's not why, that's just a restatement of the restriction. And I've seen plenty of that. What you want is, we think it's going to create too much traffic, or we think that there's going to be too many people living at this location. Something based on fact. Those are just examples, but not conclusory statements. If there's an interactive process, then that should be included in the decision. And then if there's an appeal process, that should be included in the written decision. Typically, you have 10 days to appeal the decision. And then, as I've said earlier, these reviews of reasonable accommodation requests should not require a public notice and a hearing process. They involve disability, and there is really not a reason to go through a whole public and notice process. Next slide. Thank you. Let me just say a few things about reasonable accommodation ordinances. This came up with the city of LA, and I think it came up with a few other cities when I was working with them on adopting ordinances. Zoning is considered, zoning decision-making is primarily local. It's this phrase we talked about last time, all zoning is local. And that there's typically, in decision-making process, the public has a right to know, the public has an opportunity to be involved. So the way we addressed that in the city of Los Angeles was to not have a public notice and public hearing, but to inform, but to have it just, what I call a desk decision, administrative decision by whoever is appointed to look at reasonable accommodation requests. That person makes the decision, and then notice of the decision is given to adjacent neighbors. Some jurisdictions say abutting neighbors, but these are adjacent neighbors. So that's across, on the sides, and behind. So they receive notice of the decision. So it's extremely limited notice, but we thought it was a pretty good compromise. It was proposed by the city attorney. So it's not that no one gets any notice and it's all done in secret. That seems, to the public, that seems unfair. But to the neighbors who are potentially impacted by the decision, they will receive notice. And they are also the only parties that have a right to appeal a decision granting an accommodation. No one outside of those getting notice. So there have been variations. Cities have taken different approaches on it, but it's just something to think about. The other thing, which is very, very important to us, in LA, we have a very big and effective public communication systems. Any application that's filed in the planning department for the city of LA, any decision made on a planning matter goes, there's a direct communication that goes out to, it's available to everyone in that particular part of the city. It's not like they get the decision automatically, they can sign up for it. But the point is that everything is available to the public. And with fair housing, reasonable accommodations, we didn't want that. Because we think it raises serious privacy concerns. Just even the location of recovery residence, who the operator is, who was seeking the accommodation, people who might have submitted comments in the fair housing reasonable accommodation request. So there is a marker on requests on fair housing reasonable accommodation applications in the city of Los Angeles, a specific marker which indicates that those are excluded from the public getting immediate access to it. It doesn't mean someone, actually, I think we have limitations on what someone can even get if they heard about an accommodation being granted or filed. But the main thing is to keep it out of that system. So that was it was a long negotiation process for that one, but I think it's a pretty good ordinance. There are others since then in other jurisdictions that are potentially more protective. So, okay, so what happens if your accommodation is denied? That depends somewhat on what kind of process local government has. But in many cities, you have a first right of appeal to the planning commission, and then maybe to the city council. You can file an administrative complaint with HUD. I have an asterisk about exhaustion of administrative remedies. I would say that may or may not be required. It's the safest way to go, because HUD is going to ask you, did you go through all the processes that you could with local government? As we know, some courts don't think you need to. If it's land use and zoning, you could file directly with DOJ. That's a possibility. And then there's also the possibility of filing an action in court. Do we have one more slide or not? I'm not sure.
Yep, I think that's the last one.
Okay, cool. Okay, so I've kind of spoken about these before, but these are kind of key elements if you're working with local government to draft an ordinance. The analysis should be only those 4 factors that we talked about. What you don't want local government to bring in to a reasonable accommodation analysis is anything related to a general welfare standard, whether granting the accommodation would adversely impact property values. I've seen all sorts of things thrown in. It should be just those 4 factors that we talked about before. Time frame for decision making is really important. Avoiding a public notice and hearing process, not having a fee requirement, knowing who the decision maker is and what the appeal rights are. Those are that's the basic framework. You could also include the requirement of engaging in the interactive process. That is it. Are there any questions? I think we're finishing right on time. I want to respect everybody's busy schedules. Is there anything thrown in there? Or are we okay?
No, I don't see anything else in the chat.
Okay.
Anyone have any last minute questions or comments for Kim today?
Oh,
Yep, we just,
Thank you for the great, let me turn my camera. Thank you so much for the great session. I really did appreciate it.
Oh, good. Thank you. Okay, so the last session is, what did we call it? Kind of an organized free-for-all?
the organized free-for-all, hot topics, you name it. Yeah, so
Yeah,
we will,
yeah.
we'll be looking at the parking lot, which we've been capturing questions and things that we've not fully unpacked throughout the series. So we'll be reviewing that document, pulling out the greatest hits, and so Kim will cover things that are really being driven by the individuals who've participated. And if we get a spillover, who knows? We may
Yeah,
ask
we'll
you back
see.
for an
Yeah.
encore, Kim.
Yeah, and thank you, Tim, for letting us take your proposed project through the analysis. I think it's helpful for everybody. So thank you all.
Well, thank you. I haven't burned my free session, have I?
I don't think so. All right, take care, everybody. Bye-bye. See
All
you
right,
next
folks.
time, I hope.
Take care.
Bye.
Hope to see you next week, same time.
Okay. Okay, bye.
Bye.